With your testimony, I'll remind you that you are under oath. Go ahead. In this matter, you're requesting money damages totaling $747. Can you please tell the court how do you get to that amount?
So there's no damages. And when he says that I broke the lease, if you can see on the date right here, I don't know if you on right here. It says from when I started in February and my lease ends in August 27th. And he's saying I broke my lease, but I have this right here. This is a copy of my lease. And right here's all of my receipts for paying my rent
Sir, I
on
cannot
time.
hear you.
Can you hear me?
Now I can. Go ahead, sir.
So is what I was saying though, is right here, this is a copy of my lease of from when it started from February 27th. I signed a 6-month lease and it's right here till August 27th. That's a copy of the lease. And then I have all of my receipts that he signed and gave to me from my security deposit all the way to my last month's rent. So when he says I broke my lease, ma'am, I moved out on the day my lease ended. I never renewed it, but in his mind, I asked him, I did come and ask him just to have my options open if I were to go that route, if I could renew my lease. And we did, he's like, yeah, you can, like, I didn't know if he had somebody else lined up to take my spot at the house or not. So I'll just have my options open. I didn't sign no new lease. Nothing went further than just having my options open. So when he says I broke my lease, I think he has me confused for the other people that moved out the same day I did, because they for sure broke their lease, because you can only sign a 6-month lease with Chris. And then people moved in a couple months after I did and they ended up leaving the same day I did. So I think he has me confused and breaking the lease with that other couple. But right here, if you need me to flip through these, I can flip through these, my receipts to show that I paid rent early or on time every single time. My security deposit receipts right here, and right here's a page for what my lease was. So I didn't break no lease. But to answer your question on how I got to that money is because I had to pay for the police to give him the papers. So I would like to get reimbursed for that. There's a $53 filing fee. When I came to Chris and I asked him for my security deposit because I didn't break a lease, nothing got broke, I didn't damage anything. If anything, that my spot left a lot cleaner than when it started. I cut grass at my job to do any of that.
Can you hear me, Mr. Saints? Mr. Saints, can you hear me?
And yeah, the
Mr.
five.
Saints, I didn't hear anything you said. You froze. So you were explaining to the court that you had hired somebody to serve Mr. Maduka, but then after that, I did not hear anything
Yeah,
else.
I had to pay the police to give him the papers, to serve him for the papers for court. So I'd like to be reimbursed for that. There's a $53 filing fee, and then the security deposit itself was $550. And then if I could get paid for some hours that I had to miss work due to this.
Anything else, sir?
No, ma'am.
And just so I'm clear, you're signed a 6 months leave from February 27th, 2025 through August 27th, 2025. Is that correct?
Yes, ma'am.
Okay. And you indicated to the court you moved out August 27th, 2020 or 2025.
Yes, ma'am.
When you moved out, did you have to turn in keys or anything like that?
Yes, ma'am.
Were those keys turned in?
Yes, ma'am. I texted Chris and asked him where he would like me to leave them, and he told me to leave them in my room that I was renting, and I did. And I took a picture and sent it to him, and I left peacefully.
You've indicated to the court that you requested your $550 deposit. Is that correct?
Yes, ma'am.
Okay. Did you ever receive that, sir?
No, ma'am.
Buckle up, guys. Today we are diving into a tense courtroom dispute. Right from the start, we meet Mr. Saints, the tenant, presenting his case under oath. He meticulously lays out his lease, receipts, and claims, challenging the landlord's accusation of breaking the lease. The suspense builds as we wait to see whether his detailed evidence will hold up in court and if the judge will buy his story. The stage is set, and tensions are already palpable.
Did you ever receive a letter from Mr. Maduka regards to that security deposit?
No, he told me verbally to take him to court if I wanted it.
At any time, did Mr. Maduka give you any sort of letter indicating what that money was going to be used for?
No, ma'am.
When you left the residence, that being the rental place, did you give a forwarding address?
Yes, ma'am.
And how did you give that forwarding address?
Text message. I've texted his phone.
You've indicated to the court you did inquire in regards to specifically the possibility of extending the lease in this matter. Is there anything within your paperwork that you held up to the court, the date frame, about extensions of leases?
No, ma'am. It does say in my lease to give him a 30-day notice of when I'm moving out, which I did. When I gave him my last month's rent of being there, I told him this was my last month of paying rent. So he did get the verbal, warning or whatever within my 30 days of moving out.
Is that within your contract, sir?
Yes, it says in there to let him know when
Can you read that to the court in this case, that paragraph?
I'm gonna have to find it if you give me a moment, please.
Sure, go ahead, sir. Mr. Maduka, do you have a copy of said lease?
Yes, madam.
Do you know what paragraph that would have the 30-day notice and as far as a extension of said lease?
Let me go.
All right, I found it, ma'am.
Go ahead and read it, sir. I'm
Um,
not going to be able to read that from the screen, so either you need to read it to the court or screen share it, but I can't read from that distance, sir.
can then. Oh, sorry. I'm sorry.
Nope. If you can go ahead and just read the paragraph, sir, that's fine.
It just says, tenant shall give 30-day notice before moving out. I was gonna just try to flip my camera real quick just so you can see where I was talking about. It says, tenant.
Sir, I
You can't
cannot
see
read
it?
that. No,
All right.
it is
Yeah,
way too small. So you
I'm
either need to
sorry.
screen share it in this case or just read the paragraph.
It just says on the section for the security deposit, it's just there's bulletins. There's 5 bulletins. It says for clean up outstanding rental pays, blah blah. But it just says tenant shall give 30-day notice before moving out. I I don't know how to screen share.
Nope, it's all right, sir. Do you know what page that is on, sir?
This is they're not numbered, but it's the second one from the back of the lease on the
So
top,
there
right on.
is the final, listen carefully, sir, is the final page the page that you signed?
I initialed them all, but the final, yes, ma'am.
So it would be, and what does the top of the second to last page indicate? What's that paragraph?
Security deposit, and then right under there, there's 5 circles for bulletins that are outlined darker.
And how many total pages is that document, sir?
There's 9 pages, including the front, so 8 pages with writing on it that I had to sign.
Is there anything else you'd like the court to know, sir?
No, ma'am.
Very good. Mr. Maduka, do you have any questions for Mr. Saints? They need to be in the form of a question. This is cross-examination. You will be given a chance to testify, sir. If you don't have any questions, that's perfectly fine. But again, sir, they need to be in the form of a question. You can't just start saying stuff. You have to ask questions. Do you have any questions for Mr. Saints?
No, Judge.
Very good. Thank you. Mr. Saints, do you have any other witnesses?
That, no.
Very
ma'am.
good. Any exhibits, sir?
No, ma'am.
Very good. You are done at this time. In other words, you would rest. Is that correct?
Yes, ma'am.
Very good. Mr. Maduka, in this case, do you wish to testify or do you have any witnesses you wish to testify?
I wish to testify.
Very good. I'll remind you, sir, you are under oath. What would you like the court to know?
I would like the court to know that he approached me on August 24th, 25th, said that he would like to renew his lease because his lease is up in August 27th. And then we agreed at the price because I was going to increase the price, but we talked back and we settled by 550. So on August 25th, I have the text messages that point that he sent me. You know, it's can I read it to you? Hello?
Yeah, I'm listening, sir. Go ahead, continue.
Okay, can I read the text messages that he
Go ahead,
sends
sir.
me?
Yes.
Okay. In August 25, he said, "Good morning. I was wondering about what was going on with my new."
Here, the focus shifts to the critical lease details and the 30-day notice dispute. The judge probes the tenant, asking for proof and clarification, and Mr. Saints explains how he gave notice verbally and via text. This segment highlights the clash between written contract requirements and verbal actions, creating real tension. You can feel the uncertainty. Will the court side with strict contract interpretation or the tenant's evidence of good faith?
Lease papers. So I respond back. I say, "Good morning, and I will bring it to you when I'm done with it." And then he respond back. He said, "All right, sound good. I just did not want you to forget about it." So that's August 25. And then August 26, he texts me. If you have the list done, I would appreciate if you could drop it off to me today so I can go over it and read it and give it back to you right after work tomorrow. I said, "I will bring it to you when I get back home." And then December August 26th, he texts me. When I said, "I will bring it to you when I get back home," he said, "When is that going to be?" I said, "Tonight or tomorrow." He said, "I was hoping tonight, but I'm going to bed." So in August 27th, he texted me. Because I said I will bring it back. He said, "I was hoping tonight, but I'm going to bed. I will see you tomorrow and hopefully get it then. And it might take me until the next day until I get it back to you. But it's all good. I will see you tomorrow. I hope all is well." I said, "Okay." So August 27th, he texts me. He said, "Could you meet me at the house around 2 o'clock?" I said, "Yes, I'm bringing your list with me." So when I get there to give him the list, that's when he said that he's moving out. But he already completed with the text messages. And then the person that I was supposed to rent that already tell them that he resigning the lease. So he sent me these text messages that he wanted, and so when he said he getting off at 2 o'clock to meet him at the house, I told him, okay, I'm bringing the lease with me. It's okay. When I get there, that's when he said that he's moving out on the 27th.
Anything else, sir?
Yes, madam. And then I'll tell him. He said that he's moving out. That so I told him that he already, and I have his list to give it to him to sign, like he asked. So when he said he's moving out, next thing he texts me that I need to give him his security deposit. I told him that you already prepare your new list, and you verbal commit that you you resign your list. You never gave me 30 days notice, 30 days that you're moving out. You approach me and say you want to renew your list. So that's how that.
Mr. Maduka, what is a rent amount a month?
Is $550.
You've heard Mr. Saints testify, is that correct?
Yes, madam.
In this case, he's indicated to the court that he notified you 30 days beforehand by text that he was planning to leave. Is that correct or incorrect?
It's incorrect.
When did he first tell you he was planning to leave?
On the 27th, the day he left. Because he approached me on the 24th, 23rd that he wants to renew his list. He never said that he wants to move. If he said that he wants to move, he won't be texting me and said that where his new list. So the day he told me that he's leaving is on the 27th.
Hey, Mr. Maduka, you've heard Mr. Saints testify in this case that the pages, as far as the document, was 9 total pages with 8 pages of written lease agreement. Is that correct?
Yes, madam.
Okay. And can you read to the court in regards to specifically renting out at least 30 days notice? What is your understanding of that? If you could read that to the court.
I understand that if he's in a good condition, if he's in a good time, and then if his lease is up, he should give me.
Listen carefully, Mr. Maduka. What the
Okay.
court is asking is this. In the lease, there is a section in regards that the party has to give 30 days notice. Is that correct?
Yes, madam.
Can you read that to the court? What is required in giving notice? What does that section state?
Okay, it said that clean up outstanding rental payments, damage to the property, damage to the appearances, supply, if any. Any outstanding payments, tenant shall give 30 days notice before moving out.
30 days notice, how though, sir? How is that notice to be given?
So the tenant's supposed to give it to me, tell me, inform me that they are moving.
And how was that notice to be given? Was it to be in writing? Was it to be by text? Was it to be oral? Can you tell the court?
By hold on, I'm sorry, hold on, please. Let me really make sure. Okay, okay, I'm reading. Let me read it loud. Okay, I'm reading. It said that the party acknowledges that the expiration or termination of the agreement, the landlord will return security deposit less any proper deduction to address agree upon between the landlord and the tenant, no later than 30 days.
Sir, so listen carefully. No, listen carefully. Mr. Saints has testified in this case that he had to give you 30 days notice that he was not renewing the lease. Is there a section within that contract that indicates how that notification was to occur?
Look here. No, but Judge, he did not give me 30 days notice. The day that he told me that he moving is on the 27th of August 27th, the day he moved.
All right, Mr. Manduca, quick question. I'm going to first jump over to Mr. Saints real quick. Mr. Saints, before I
ma'am.
forget, in this matter, you've indicated to the court you did give notice. How did you give notice, sir?
The first time was verbally when I had paid my last month's rent, and then on August 27th, after he got there, I was already packed up. Already had most of my stuff packed up, moving. Answer your question though, I verbally did it when I gave him the money for my last month's rent, and then as well on the 27th of August, I did tell him, well, I'm moving out, so this is your 30-day notice, and I provided him a forwarding address.
Thank you, sir. Mr. Manduca, how would Mr. Saints pay you for rent? Was it typically the first of the month, or how did that occur?
His rent started at the 27th of each month. So he paid the rent on the 27th, either 26th or 27th of each month. But when he paid
Was
his
there
rent,
ever a month, Mr. Manduca, that he did not pay rent?
no, madam, he always paid his rent. But on the 27th, that when he paid his rent in he told me that he wants to renew his, and that's why he sent me all these text messages. And I pointed out
The
that no,
court
he
has
never
heard
gave
you
me.
indicate, listen carefully, Mr. Manduca. The court has heard you indicate specifically those text messages. So the court is aware of that. My next question for you, Mr. Manduca, is at any time did you return the security deposit?
No, madam.
Did you send him anything in the mail indicating that you weren't going to return the security deposit?
My judge, he came to my. Okay, I forget that. He
Mr.
came to my
Manduca, please
house.
answer the court's question. Did you send out any mailings indicating that you weren't going to pay the security deposit?
No, judge, he came to my house. So when he came to my house, that's when that I told him that I'm not going to give him his security deposit because the new lease that he tried to sign.
Now the landlord, Mr. Maduka, takes the stand, and things heat up. He reads text messages to argue that the tenant promised to renew the lease. The judge pushes him on contract specifics, scrutinizing every claim. The back and forth exposes contradictions and raises stakes, keeping viewers on edge. This is the most suspenseful part, as it's unclear who will prevail, the tenant's meticulous records or the landlord's version of events.
He came to my house, and then that's why that I didn't send him because he verbal come out. I verbal tell him. I don't know how he find my house. He showed up to my house, and that's when that I told him that I'm not going to give him his security deposit.
Mr. Manduca, then, the court has indicated you received a text on August 25th from Mr. Saints. Is that correct?
Yes,
Very
madam.
good. And in that text, it's indicated that he had inquired about new lease paperwork. Is that correct?
Yes, madam.
Very good. When a party wishes to renew with you, do you have them sign new paperwork?
Yes, madam. When I get the new,
Would it
when
be,
I get the new.
and so this new paperwork would be basically the same type of contract that you had before, except with different dates. Is that a correct statement, sir?
Yes, madam.
If the paperwork is not signed, then in this case, in this matter, is there then a lease between you and the other party then?
But because when the day that I supposed to bring his list, when he texted me, I was out of town. So that's why I told him when I come home, I will give him the new list. And that's what the new list that I brought to him on the 27th. When I came back, that's the day that I told him that I'm bringing the list. And that's the day
Is
that said that he moving
okay.
out. The same day.
Mr. Maduka, listen carefully in this case. Do you have any other witnesses you wish to testify?
No, madam.
Do you have any exhibits you want the court to know about, sir?
Beside the text messages that I point, that's that's what I have. The text
Okay.
messages that I want to
So
point.
what you read to the court is what you want the court to consider. Is that a correct statement?
Yes, madam.
Very good. Mr. Saints, do you have any questions for Mr. Maduka? They have to be in the form of a question, sir. If you don't have any questions, that's perfectly fine. But in this matter, do you have any questions?
No, ma'am.
Very good. Mr. Maduka, you have no exhibits at this time, correct? Besides what you've indicated and you read the text messages, is that correct?
Yes, madam.
And secondly, in this matter, you have no other witnesses, is that correct?
Yes, madam.
Very good. In this matter, I want to make it clear to both parties, either side can file an appeal, but that appeal has to be filed within 7 days in this matter. The court in this matter is going to give its finding in this matter. It is clear to the court that there was a contract between the parties in this matter. The court did allude to both parties. It was approximately 9 pages with 8 pages being written. It was for a lease between February 27, 2025 to August 27, 2025. Specifically, in this matter, the plaintiff is suing for the rent deposit of $550 and also court fees in this matter. I do note the court did, upon its questioning, did inquire specifically regards to the 30-day notice in this matter. Plaintiff alleges that he gave notice at his last month's. In this case, it would have been towards August 27th, July 27th at the payment. Defendant in this case, the landlord, indicated that there was no notice given, and specifically in this matter that he found out first about the tenant leaving, specifically in this matter on the 25th when the tenant inquired about new lease papers, and that there was a series of texts inquiring about when the new lease paperwork is going to be dropped.
The tension finally breaks as the court delivers its ruling. The judge carefully analyzes the lease, the 30-day notice issue, and text messages, ultimately siding with the tenant. The verdict awards the $550 security deposit, plus fees, under Michigan law. The resolution is satisfying, highlighting the importance of documentation and legal clarity. Don't forget to like the video and subscribe to the channel, and we'll see you in the next.
Dropped off. Ultimately, the tenant did, in this case, the plaintiff, move out on the 27th, and then inquired about the security deposit, which the defendant in this case indicated that that would not be given. With this matter, the court then in this case does find the following. It is clear through the testimony presented in this case that the tenant moved out on August 27th. And while there was text messages back and forth between that, it is through the lease, because it's not signed. There was an intention, but nothing signed. So there was not a contract for a new lease. Defendant in this case argues 30 days notice, but ultimately it is clear to the court that there was an intent through the text that there was going to be in a basically non-renewal of the lease in this case. The plaintiff testified in this matter, and the court has to find in this case by a preponderance of the evidence, 51% out of 100, that it is credible. The tenant paid on time. The tenant gave the information that he was moving out. Not to mention on August 25th, there was an inquiry of the new lease, whether or not it was going to be followed through. The court in this case does find in favor of the plaintiff in this matter. However, the court will only award the following: for the security deposit of $550 with filing fees of $50 and a proof of service fee of $33.10. The Michigan law is clear. When a rental in this case occurs, security deposits have to be returned within 30 days unless the landlord gives notice to the tenant in writing why they're keeping that security deposit. That did not occur here. So in this case, the court does find in favor of the plaintiff in this matter. Now, in this matter, as I indicated earlier, both parties